Hey everyone, I hope you're doing well and staying safe during this time. If you're new here, welcome to the channel. Like I said, thank you so much for checking me out. If you haven't done so, please make sure to hit that subscribe button just right below the video. Cool, thank you so much. I really do appreciate it. And if you're returning, welcome back. Thanks again for your support. I truly do appreciate having you here.
Breaking. Judge denies Ripple executives' motions to dismiss SEC lawsuit. Annalisa Torres, a judge for the United States District Court for the Southern District of New York, has denied Ripple CEO Brad Garlinghouse's and co-founder Chris Larson's twin motions to dismiss the lawsuit that was brought against them by the U.S. Securities and Exchange Commission in December 2020, delivering a blow to the individual defendants. The motions were filed by the two top Ripple executives last April. The court finds that the agency has plausibly alleged that Garlinghouse and Larson recklessly disregarded the facts that allegedly made Ripple's XRP amount to the unregistered sale of securities. The SEC has also plausibly shown that the individual defendants made domestic offers of the token. Moreover, the court rejected the claim that their sales were predominantly foreign. In addition, the judge also denied the SEC's motion to strike Ripple's make it or break it fair notice defense. As reported by You Today, the SEC filed the motion last April and later added several letters of supplemental authority in order to bolster it. The court shall not conclude that Ripple's affirmative defense is invalid at this stage of the case. The judge argues that the agency will not suffer undue prejudice as a result of the continuation of the defense. Stuart Alderety, Ripple's general counsel, has already commented on the decision to shoot down the SEC's motion to strike, claiming that there's a serious question whether the agency provided the company with fair notice. Garlinghouse also took to Twitter to describe the fair notice ruling as a huge win for the defendants without commenting on his failed motion to dismiss the lawsuit. Ripple moves to strike rebuttal report on XRP price manipulation. Ripple has moved to strike an impermissible rebuttal report written by securities and finance expert Dr. Albert Metz. Metz, who has worked for the U.S. Department of Justice, submitted his original report on October 4. He conducted an event study in order to determine whether or not Ripple was able to manipulate the price of the XRP token with its announcements. He came to the conclusion that certain news and public statements did influence the token's performance. Alan Farrell, professor of securities law at Harvard Law School, argued that XRP was moving in tandem with the broader market. Metz submitted the first rebuttal report in November in response to the defendant's expert. The most recent one is based on counterfactual analysis, aiming to determine the token's expected returns without Ripple's involvement. Its purpose is to quantify the economic significance of the company's public announcements. The defendants argue that the new version of the initial rebuttal report doesn't contain any error corrections. Instead, it aims to attack the conclusions made by Dr. M. Laurentius Murray and Professor Daniel Fishel, Ripple's rebuttal experts who claimed that Ripple's announcements only accounted for a modest portion of the token's volatile price moves. The company's lawyers claim that Metz is not supposed to have the final day in discovery, thus Magistrate Judge Sarah Netburn to exclude the report. They add that the economic significance part should have been included in the original report. Ripple has asked the court not to grant a continuance of the January 14 expert discovery deadline since prolonging the case would further hurt its ability to do business in the U.S. The agency has objected to the defendant's motion. XRP soars 10% after critical update in legal battle. This is what you should know. The price of XRP has begun moving on its own as the legal battle between payment company Ripple and two of its executives versus the U.S. Securities and Exchange Commission, SEC, sees a new development. According to a document filed with a court in the Southern District of New York, the district judge will allow the company to use a fair notice defense. In other words, Ripple will be able to argue in its favor that the regulator failed to inform it that XRP and its public sales could potentially violate U.S. law. As previously reported by Bitcoinist, the payment company claims it asked the SEC about its token offering. However, the company claims the fails to provide regulatory clarity regarding XRP. In support of Ripple's defense, there are records of two separate reports from legal firm Perkins Coie on the legality of the company's token offering. Date as far as 2021, the reports attempt to demonstrate that Ripple seeks legal consultation before the sales. The report also could be used to demonstrate Ripple even changed its business model to remain compliant with U.S. laws. Stuart Alderety, general counsel at Ripple, stated the following regarding today's court decision. Today's order makes it clear there's a serious question whether the SEC ever provided Ripple with fair notice that its distributions of XRP, since 2013, would ever be prohibited under the securities law. Good to see the judge rejecting the SEC's attempt to prevent Ripple from pursuing its fair notice defense. It's even more imperative that the sun sets on the SEC's regulation by enforcement approach. XRP decouples from general market sentiment. The XRP community has celebrated the recent court ruling as they consider it will provide an advantage versus the regulator. Commenting on this development, legal expert Jeremy Hogan commented the following. I know you've been working on the pending rulings in the Ripple v. SEC case this week. On behalf of myself and certain other interested parties, we'd really like to get those rulings today if possible. Boom. And I don't use that term lightly, the SEC's motion to strike the fair notice defense is denied. This is the one I've been waiting for. Now the SEC has something to lose. As a result of these recent developments, XRP trades on an uptrend in lower timeframes. The cryptocurrency has quickly re-entered the top 5 by market cap after a long period of absence. Although a significant win, according to the above-mentioned expert, the legal battle continues. As of press time, XRP trades at 80 cents with a 9.1% profit in the last 24 hours. The cryptocurrency used to occupy the third spot in terms of market cap, only surpassed by BTC and ETH. Remains to be seen if it will reclaim its spot. SEC will lose lawsuit against Ripple, former SEC official predicts. In December 2020, the U.S. Securities and Exchange Commission filed a lawsuit against Ripple and its chief executives, Brad Garlinghouse and Chris Larson. According to the SEC, Ripple traded $1.3 billion in their cryptocurrency XRP as a security without notifying the commission. Ripple and other parties have now rebutted the watchdog's judgment with claims of bias. Several significant court actions have occurred over the last year, with a series of back-to-back petitions filed by both sides either being granted or rejected. Twists and turns. In the years since the SEC sued Ripple, the financial community has been divided over the legitimacy of the regulator's claims. While a number of twists and turns have occurred in the case since 2020, no substantial rulings have yet been rendered. In any case, the most recent developments suggest that Ripple is on the winning side, for now, as it won a number of significant motions that could be crucial to its fair motion defense. Specifically, the court last week ruled in favor of Ripple, unsealing 2 important documents that the company argues will offer some kind of assurance on how the agency categorized XRP when it initially entered circulation in 2012. Lawsuit against Ripple, a major upset? Now, during a recent podcast with Thinking Crypto's Tony Edward, Joseph Hall, the former SEC managing executive for policy, discussed the status of the case, how it has progressed so far, and what to expect moving forward. I'm not sure what the SEC intends to prove in the XRP action either, Hall said, adding that he remains baffled as to why the SEC brought the case in the first place. He said the Ripple network has been operational for years prior to the filing of a lawsuit against them at the last minute. The ramifications for the SEC and the crypto business in general are enormous. Shut down. According to Hall, the SEC has a lot riding on this lawsuit, and their entire regulatory effort may be effectively shut down if they fumble on the merits. Ripple has a strong defense on the grounds that the SEC failed to give fair notice of its investigation, according to Hall. Individuals and corporations are required to be notified if they are being scrutinized by the regulator. The XRP community has expressed its dismay and concern since the beginning of the lawsuit. In Hall's view, the same is pretty compelling and might matter to a judge, but might not necessarily act as a trump card. The game-changing question. According to Hall, the lawsuit against Ripple may not end up in the manner anticipated by the SEC. A judge in a lawsuit may only ask one question. If you are aware that XRP is a concern and have knowledge of it since 2012, why now?
I'm your guy. I will keep you posted. I'm your advocate. I'll be back on a daily basis, usually multiple times per day, with these videos to keep you updated with everything going on. So, I hope you enjoyed the video. If you haven't done so, make sure to hit that subscribe button. Feel free to share any of my videos with your friends, family, social media, or anybody who may care to listen. Thanks so much for your continued support. I'm always here for you. I want to help you through this time. So thank you so much for continuing to choose me. Enjoy your day, stay safe, and I'll catch you again probably in a couple hours. Thanks everybody. See you later.